Hello, everyone. My name is Alexander Nam, and I'm a law clerk here at Lawes Parker. Thank you for joining us for this new webinar series with the Home Care Association of Louisiana. Today's webinar is entitled Voluntary Disclosures, What to Do When Something Goes Wrong. Our presenters for today are Lester Johnson and Richard Pecore. Richard Pecore is a 30-year attorney and senior counsel here with Lawes Parker. He's been with the firm for the past 12 years. He focuses mainly on administrative appeals, regulatory healthcare compliance matters, billing contracts, and compliance programs for our clients. Prior to joining the firm, Mr. Pecore worked on improving workplace safety compliance and heavily industry and the oil field, as well as on personal injury cases involving asbestos and silica lung injuries. His office is in Houston, Texas. Our next speaker is Lester Johnson. He's a partner here at Lawes Parker and is the supervising attorney for the firm's Baton Rouge office. In addition, Les also serves as co-leader of the firm's health law practice group. Les helps clients navigate the myriad of regulatory compliance and business issues facing today's healthcare providers and practitioners. Core areas of Les' practice include handling Medicare and Medicaid appeals, as well as Medicare and Medicaid participation and compliance. Quick reminder, if you have any questions throughout the presentation, please feel free to type them in the chat box and we will address as many as possible at the end of the presentation. Without further ado, I present your speakers, Lester Johnson and Richard Pecore.
All right, hi everybody. How y'all doing? I'm going to start us off today with the first couple of slides. We're going to be, I guess you can go to the next slide. Are you controlling the slide or am I? All right, so we're going to start with background on the OIG civil penalty laws in general, but then we're going to start mainly about two different self-disclosure protocols. So I'm going to do the OIG one. Richard's going to do the CMS self-referral disclosure protocol. These are basically just ways to report non-compliance with the law or overpayments and under a program that would allow you to, I guess, avoid some of the penalties that could otherwise be applied to the conduct. Go to the next slide. All right. Okay, so OIG, Office of Inspector General of HHS, has the authority to assess civil monetary penalties for several different laws, mainly the False Claims Act, anti-kickback violations, Stark Law violations, any use of excluded employees, even beneficiary inducement kind of laws, patient dumping, and TALA violations. So anything regarding possession, use, or transfer of toxic agents or certain agents or toxins, improper or incomplete Medicaid drug pricing and rebates, misuse of words and emblems. I mean, there's tons of penalties they can assess for things that are not just payment rules. Some of them are just literally the last one, using CMS's or HHS's logo improperly on your website. Of course, you're not getting that much trouble for that, but they will make you remove it and they can fine you. Go to the next slide. All right, so they've created a self-disclosure protocol. It's available for any violation any conduct that potentially violates federal, criminal, civil, or administrative laws for which a civil monetary penalty applies. So that's, again, anti-kickback statute, False Claims Act, use of excluded employees. Those are some of the more, I guess, expensive ones. It does cover Stark Law violations, but not for ones that don't also violate the anti-kickback statute. Stark and anti-kickback statute, Stark Law and anti-kickback statute are two very similar laws in that they both would prohibit essentially bribes for referrals, kickbacks for referrals. But Stark Law is a civil law, not criminal, so intent isn't necessary to prove a violation there. So you can just have the wrong language in a contract and you can violate Stark Law. So you don't have to have any kind of improper intent, and it's only civil. That's why the OIG, since when they're doing the disclosure protocol, they don't want to see just civil Stark Law violations. There's a separate disclosure protocol run by CMS, which is obviously under HHS, but they run that program for the Stark only violations. These are for anti-kickback and Stark, which would be Like if there was a contract with a physician that was far in excess of fair market value, that would, and, you know, paid directly based on referrals. You know, say, you know, $50 for every imaging scan ordered or every any other test ordered. That sort of situation would clearly violate both, and would be a, you know, a thing that you could report to OIG's self-disclosure protocol, even if it started as a Stark Law thing. So OIG started this back in 1998. They've done several revisions, most recently in 2021. Go to the next slide. It seems like they were trying to, over the years, they've tried to get more and more people to participate in the self-disclosure protocol. The main benefits that it gives you is it can give you a lower multiplier on the penalties that apply if it's the kind of false claim, and if it's a false claims act kind of situation or in a kickback situation where there's going to be large multiples for damages calculations, and it can allow you to avoid an exclusion. The most recent changes that occurred, they increased the minimum amounts just to make that match statutory minimum penalties. They required all the submissions to be made through the website instead of through the mail. They added references to the 2009 grant and contract self-disclosure protocols. They also have another one they're launching, I think they launched last week, that's just for any kind of corporate disclosures. That's actually run by DOJ, not OIG, but there's lots of different self-disclosure protocols or processes and programs out there. They clarified the DOJ sometimes does settle self-disclosure protocol cases. That's an issue because in the past, you know, this OIG is different from DOJ. OIG is part of HHS and DOJ is part of the Department of Justice, obviously. So in the past, you could settle with the OIG, but it didn't necessarily resolve any claims under the that the DOJ may raise. They can bring other criminal charges. Here, they're saying that they're clarifying that they do often coordinate with them and will settle these cases to resolve, I guess, all potential federal claims. They clarified that disclosures must include damages and to each effective federal healthcare program. So that would be splitting out Medicare, Medicaid, American Indian Health Plan, that sort of thing. They made technical changes to the statistics and terminology and background facts, but they did not change any timelines or content requirements or the methods for calculating damages, or the fact that time of settlement with a lower multiple, it can result in a lower multiple and an exclusion release. So the basics of the program are still there. They just made it a little easier, and they tried to, I guess, entice people to settle. Lots of people wouldn't settle with OIG or disclose to them if they thought that the DOJ could just bring charges anyway. So you get a settlement agreement with one little federal department, but another one would still bring an action against you. They don't always do that, but they do. They obviously clarified that in this update for a reason, and it's because they do often settle them. Go to the next page. So it's available, the self-disclosure protocol is available to all healthcare providers of services and supplies, including individuals and entities. They're called a disclosing party. You can disclose even if you're already the subject of a government investigation, audit, or other routine oversight activity. Lots of different self-disclosure programs in the past have only allowed benefits to someone who self-discloses if you weren't already the subject of an investigation. That's not the case with this. But it has to be made in good faith. So you can't get rated and then self-disclose. That's not going to fly. So you can use it even if you're currently under a corporate integrity agreement. And that's a big process. Corporate integrity agreements are placed on providers that have significant compliance issues, and they will basically, as part of resolving some alleged non-compliance, they will agree to enter into a monitoring agreement with the OIG, and they'll have corporate monitors kind of audit their claims and look at them over a course of a couple of years. It's kind of a detailed process, and it was unfortunate that in the past you couldn't do this self-disclosure if you were in a CIA or under a CIA, because that lasts for years and years and years. But now you can, and so that's certainly helpful. It's not straightforward, not for just straightforward overpayment. So this doesn't mean like every instance of a misbilled claim should be disclosed. This is only for misbilled claims that amount to a violation of anti-kickback statute, possibly Stark, False Claims Act, things like that. So if you just had, I don't know, build one or two too many units for a particular service, or or build too many days, that's not going to be something that you would self-disclose unless it was systemic and it was like a policy kind of thing. You did it a lot. Otherwise, what you're just going to do is correct the claim by probably adjusting the claim. There are also refund programs through various payers, and you can just sometimes send checks, but lots of times I find the easiest way is to just re-adjudicate the claim itself if it's that simple of a violation of a overpayment. So again, the OIG's process is not for stark only violations. So technical little violations, even if systemic, wouldn't be appropriate. This would be when if it's a massive overpayment, it would be if you're concerned that they may be able to, I guess, allege that some kind of improper intent was involved, and that it therefore falls under the False Claims Act. Go to the next slide. So the process of submitting a self-disclosure. A, you don't want to do this without consulting an attorney first, but B, you can submit it by, I think it's now just online through the website. I guess maybe you can still do it by mail. I was thinking it was only online, but we'll look into that and clarify. Internal investigation and damages calculation must be completed within 90 days of the date of the initial submission. That's important because if you have to review a ton of claims and look through, sort through a mountain of medical records in order to determine the full scope of your submission, you've got a ticking time frame, as soon as you start it. So you've got to finish your damages calculation within 90 days, and you should keep that in mind. You ensure that any conduct is ended. That's the first thing. Anytime you're going to disclose anything to the government, or hell, if they knock on your door and start investigating something, and then you discover something wrong, stop that conduct immediately. You may not want to be really loud about it, but you definitely want to stop it right then. With the self-disclosure process, you would make sure that all the conduct is ended. You verify that and have proof of that. For anti-kickback arrangements, sometimes you've got contract provisions, so you can't just immediately end things, but you've got 90 days to do that. Any other corrective action should be completed at the time of disclosure. So if there were policy changes that you needed to make or anything like that, any safeguards you could put in place in your EHR system, you go ahead and do that before you disclose. That way in your disclosure, you can tell them that we've already done X, Y, and Z to prevent this from happening again in the future. It's just the damages calculation that can be drawn out longer like that. Go to the next slide. So in the disclosure, you're going to have to provide a lot of information, namely the name, address, tax ID, and MPI of the disclosing party. If the disclosing party is owned, controlled, or part of a system or network or other organization, you have to give a full org chart, explain the relationship, names, and addresses of affected organizations and departments. You have to disclose all the government payers to whom the disclosing party submits claims, or a statement that they don't, that you don't submit claims. Maybe you just hired someone you're not supposed to hire, and actually submitting claims. So it's not a money situation. It can still be a violation of various federal laws. So you can still use the disclosure protocol as long as there's a civil monetary penalty that can apply to the conduct. Go to the next slide. So all disclosures have to give the name, address, email address, or whatever disclosing party's representative, a concise statement of all relevant details of the conduct. So the types of claims, transactions, conduct given rights to the disclosure, the time period when these occurred, names and individuals and entities involved. So, the doctor involved, the nurses involved, whoever was involved in, say, treating a patient, if it was a False Claims Act situation, or, whatever it may be, everyone involved, all the entities. And then you have to list all the federal criminal or administrative laws that are potentially violated. This is definitely something you do not want to write yourself. You want your lawyer to write it. You're going to try to be all inclusive of everything, but you're not going to try to do list every potential 200 different laws if you can avoid it. But you don't want to be making that choice. Have your lawyer make that call on what you do and do not disclose, because at least minimum you can blame us, and we can take the blame if they're upset about what was disclosed or they think maybe something else should have been disclosed. Let your lawyer make that call. Go to the next slide. So you have to calculate the actual damages or an estimate of the damages broken down by federal program. So if that's not determined, you got to certify that the estimate can be completed within 90 days. You have to describe any corrective actions you've already taken. Again, you'll want that to have already occurred. You have to say whether or not you have knowledge of any governmental inquiries or investigations related to it. So do you think or have any reason to believe that investigation has already begun, either by the OIG or people related to CMS, or could have been a local DA? Anyone can start that kind of investigation. So statement regarding any other government inquiries or investigations into any other matter. So things unrelated to the disclosed matter. Go to the next slide. So you give the name of the individual authorized to enter into a settlement agreement. You have to give someone who can actually resolve the alleged potential dispute. And you have to certify that all information disclosed is truthful and based on a good faith effort to resolve potential liability and assist the OIG in its resolution of the matter. You have to also agree to waive statute of limitation or similar defenses to any actions filed by the OIG related to the disclosed content. Go to the next slide, which is pretty standard. I mean, obviously, any kind of self-disclosure protocol thing is going to require that sort of thing. If you're going to get the benefit of lower damages multiples and no exclusion, that's what you pay. So for false billing situations, you have to report, create a report on the calculation of your damages using either all claims impacted by the conduct or a statistically valid random sample of them. If you're using a sample, they're going to require you to use 100 units, which is kind of funny because lots of their auditors will send out audits for 30 units all the time. And it's perfectly acceptable for them to use it to take millions from a provider, but if you're calculating your damages, you're going to have to use 100 units. Honestly, it's probably, I don't know if that's going to be harmful or helpful for anyone. It's really depends on the records. It's all things being equal, it really shouldn't matter if your sample is selected properly. But 100 units is a lot of work. So if you got to review 100 different, hospital admissions, that's a ton of work. 100 different home health episodes can be a lot of work. 100 home health patients records can be a ton of work as well. But sometimes 100 is not that big of a deal if it's just, injections. No minimum precision levels required, which is also kind of odd, but you don't get to really peg the level of precision that you want with the way the statistics works. Anyway, so it's going to depend on the variability in your claims and different providers you got. There's a lot of different things that impact that, but you don't want something that has bad precision. No netting of underpayments. This is something that we do or argued for in so many appeals I can't even remember. But basically what they'll do is auditors will come in and they'll audit and find just overpayments, and they won't really consider they won't net away any underpayments. And on occasion we'll win cases on that argument that they didn't net any underpayments against the overpayment demand, but you're not allowed to do that with the OIG's self-disclosure protocol. So you can't point out all the million times that you didn't bill for something that you could have. So the report must also include the review objective, population, details on the population, the sources of data, where you just pull your claims data and your medical records is likely what you would have here. Personnel names, titles, and qualifications of the clinicians who actually saw the patients, and characteristics. What were you looking for in your sample design? Go to the next page. So if it's based on sample, then you have to provide a full list of. You don't need a statistician for this, by the way. They're going to. I think they're $5 to $7 grand typically nowadays for an initial report, but you're going to need a sampling plan that details the sampling unit, the method of selection for the sampling units, the frame, the sample size, the source of the random numbers. You're going to be using rat stats, everyone does. The source of data that you get from just your claims data from your EHR, your sample design, where did you exclude anything? What about the what date dates of service were involved, things like that. Any missing sample items or other evidence, and your estimation methodology. How did you actually estimate the overpayment amount? Simple, like straight extrapolation, or various other methods you can use. Go to the next slide. And then you're going to have to break this all down by federal payer. So it's going to be a lot of work. That's why that's why you have 90 days to calculate this. So if you're dealing with excluded individuals, this is a little different. This can be very costly depending on what job these excluded people actually do. But let's say the OIG has this exclusion database, and if you're not searching that against the OIG's list of excluded individuals, then you can end up with a massive overpayment. And it's kind of a strict liability thing. You either employed them or you didn't. There's not going to be much arguing you can do here. But when you have an excluded individual in a self-disclosure, you have to identify the individual and any provider ID numbers. You have to describe their job duties. Hopefully they are a janitor, not a surgeon. Dates of employment or contractual relationship. Background checks performed before and during the employment or contractual relationship. They want to show, did you actually search to find out if they had, if they were excluded at all? Did you try at all? Describe how the excluded individual was discovered. How did you find this out? Any corrective actions taken, including any new or revised policies and procedures. So if disclosing an excluded individual, you must also screen all other current employees and contractors against the LEIE before submitting your disclosure. So just to prove that there's only one. It's obvious if you tell them that you employed one excluded person, it kind of begs the question, how many other people did you do that to? So it should be fairly easy to identify people ahead of time, and they expect you to do that. So if you do screw up and you employed someone who's excluded, search everybody at the same time before you submit your disclosure. Go to the next slide. So damages with excluded individuals. This is very different from the claims processing, from the claims overpayment part. But if your excluded individual is a direct provider, like a doctor or pharmacist or someone ordering services, therapists, then detail all the claims submitted and amounts actually paid for that provider. If they're not a direct provider, so you're not actually billing for that person's services, like an RN or some therapists, of course some therapists can bill, billing clerks, that sort of people, then you estimate the total cost of employment. So their salary, benefits, health insurance, employer taxes, all of it. And you're going to have to multiply that by a revenue-based federal payer mix for the time period. So if Medicare was, 20% of your payer mix, then 20% of the total salary cost would be assigned to Medicare. Then Medicaid was, another 10%, and 10% would be assigned to that payer. You have to go through every federal payer till you got to all the way through it. You calculate damages separately, and all this will be, if there's different with excluded individuals, not that big of a deal, but like with calculating separately for each federal program on the claims overpayment situations can be pretty complicated because sometimes they have different coverage rules for the claims at issue between Medicare and Medicaid. So all of this can be something that you definitely want expert help putting your damages calculation together, because you really want that to be, you don't want them to question it. In March 14th, 2024, Baptist Health Deaconess in Madisonville, Kentucky, entered into a $21,402 settlement agreement with the OIG, and it resolved allegations that they employed an individual as a paramedic who was excluded, but nevertheless provided items and services that were billed to the federal healthcare program. Or programs. So, part of this 21,000 was for, maybe Medicare, part of it maybe Medicaid, but anything that's a federal program would have made up part of the, the penalty. But that's an example of one that's really not that bad. 21,000 probably seems like a bargain. If they were a doctor and they were billing directly for those claims, then all of the claims that doctor submitted or whoever would be an overpayment, and that obviously could be hundreds of thousands of millions of dollars. So go to the next slide. So Stark and AKS violation. So anytime you've got anti-kickback and start violations, meaning the conduct, is going to easily violate both, you have to explicitly acknowledge that it's a potential violation of AKS, and if applicable, start. So one's got an intent standard, one doesn't, obviously. But you're basically, let's say that you had an argument that maybe you didn't have the improper intent wasn't present. Once you disclose, I mean, you're acknowledging that it is a violation of that kickback statute, and they're going to treat it as such. So if there's a gray area or a really, really close call, you may not want to use this process because it may only be, say, a start law violation and not violate a kickback if the requisite intent wasn't there. So there could be scenarios where you disclose only to CMS and not OIG, but you need to have a really good reason for doing so if you went that path. So for these that are stark and kickback violations, you give a concise statement of all the details and relationships, just like other ones. Analysis of why the conduct violated AKS and STARK. And some things you're going to be looking at is relationships involved, fair market value, timing of payments, failure to collect payments in contract, and how long it went on. And so if a doctor's supposed to be paying rent, but you weren't ever collecting it, well, it may say that that's a violation of anti-kickback and STARK. And we fall under the dual, I guess, reporting type self-disclosure protocol reports. So if payments for services not rendered, they're documented. If payments were varied with or otherwise took into account the volume or value of referrals, you want to detail everything you can about both AKS and STARK and kind of show why this should encompass both or would arguably encompass both and can be resolved in one settlement. That would be the benefit, obviously, of doing them together. Would be you can resolve both violations in one agreement. At the next slide. The last thing you want to do is settle with OIG and then have CMS penalize you for the same amount of money for the same conduct. So, so in the calculation of damages, you can use the methods described above. You can use any other reliable method, which is then described in the disclosure. If payments varied or otherwise took into account, the volume or value of referrals, that's going to be part of your calculation. Any STARK exceptions, disclose the total amount of remuneration involved, regardless of whether it's actually offered, paid, requested, or received. Some of these laws, just the offering of remuneration is a violation of the law. So at that point, sometimes money has not actually changed hands, but you've got a contract in place or something like that. Definitely, if no money has taken place, and maybe no services have been rendered, but you think possibly you got an AKS and STARK violation, definitely contact an attorney before you disclose, because
Did we lose Les?
We might have lost Les. Let's give him a second.
Yeah. Oh, wait a second here. I was looking at something else, but when he's going through the calculation of damages, I think he was talking about any other STARK law exceptions. You must disclose total amount of remuneration involved. That's basically the value of anything of value, regardless of whether it was actually offered, paid, requested, or received. Are you there?
Yeah, did I cut out?
You did.
Weird. All right. I'm not sure where we are, but I was on 17.
But we're on the same slide. Go right ahead.
All right, go to 18. I guess I'm still not seeing it. Okay. So outcome. So actual damages are based on a actual remuneration paid and received times a multiplier. They coordinate with the DOJ when you do go through under the self-disclosure protocol. Expect to pay at least 1.5 times actual damages instead of, say, 2 or 3. based on actual reimbursements actually paid, not claimed. So they're not going to go by your funny money charges. They're going to go by actually paid amounts, charges less contractual adjustments. Minimum settlement amounts, AKS violation, 50,000. All other matters, 10. And OIG anticipates resolution in under a year for any of these reports. Next slide. So if they disclose, if allege an inability to pay, which obviously happens a lot, they'll require extensive financial information to enter into, I guess, extended repayment plans, similar to the way CMS does. You obviously want to tell them as soon as possible. You know, if it's a multi-million-dollar thing, obviously lots of times that's going to be just impossible right off the bat, and they'll understand that and they'll be okay with it, I guess. But you will have to disclose your bank, all kinds of information about your bank accounts and just across the board. I'm trying to think of all the things that are on it. The last time I did one, I swear it was like 25 pages of just attachments to the one-page form. So it can be pretty detailed. If you've already refunded the overpayment related to the conduct, they'll credit it towards the settlement amount, and you'll still pay a multiplier on damages. So you'll just be paying above it, and it'll be offset from what your damages calculation, I guess, is. Go to the next slide. All right, so lots of different settlements over the years. 2015, 60 plus settlements. They're doing more now. Sometimes they're pretty low. Sometimes they can be pretty high, but it's definitely much lower typically than when they just throw the book at you. It's not even comparable. So if it involves tons of money, you definitely want to use this process. And if it's a straightforward situation, you definitely want to use it. It's really the gray areas, and you know, sometimes it can be really complicated to come up with an amount. And so there's a lot of times where you're going to want to have someone, I guess, guiding the scope of your disclosure and trying to not disclose too much, but at the same time, not enough to where, you know, too little to where they just ask a million other questions and start doing other investigations. Go to the next slide. There's some other examples of settlements. So in 15 to 16, there were several settlements for home health and personal and hospice care. One involved claims for 2 locations without certifications of terminal illness, face-to-face encounters, or physician narratives, 9.8 million. Another one was a hospice involving claims that were not supported by face-to-face encounters, and one beneficiary was paid routine home care services where the documentation didn't support it. That was 146,000. You know, the amounts are going to be obviously wildly different and dependent on your situation. The one involving claims for 2 locations without certifications of terminal illness, face-to-face encounters, or any of that. I mean, honestly, they would have known that they're going to be in trouble the second they get audited, because they're not doing any of these things, right? On the other hand, the second one, probably a lot more of a gray area kind of situation where, like, you know, they've got documentation, but maybe it didn't quite support their eligibility, and that can be, you know, different people can have different opinions on that kind of a situation. But simply, you know, not having several key core documents is obviously going to result in something much more costly. Go to the next slide. Benefits for presumption against requiring a corporate integrity agreement, which, like I said earlier, can last a long time and be real burdensome on your operation. Starting point of damages is 1.5, not 3, plus fines, which is what the False Claims Act allows. Suspends the 60-day deadline to refund an overpayment. And so, you know, the only way to resolve any excluded employee issue. There's just no other way to settle that. On the next slide. Disadvantages opens the door to other investigations, for, you know, possibly revealing other conduct and penalties for that. There's no immunity from liability. Shortened time frame for completing the investigation, that 90-day period for doing your calculation of damages. You have to, this is the big, you have to explicitly acknowledge the conduct is a violation of these laws. So if it arguably wasn't, but was a close call, this is not, arguably not what the self-disclosure protocol is for, because you are conceding now that it is in fact a violation of the law when you do this, and they'll treat it as such. And they're going to share it with the DOJ and CMS, and that doesn't always resolve your DOJ and CMS issues. So they did point out in the recent revision that it often does, but it's not required. So that's still going to be something that might give some people pause, hesitation a little bit before they disclose, or they at least want to discuss it with a lawyer first. Go to the next slide. Waiver of Fifth Amendment rights, but no guarantee of acceptance into the program. Obviously, you're disclosing a lot, you're admitting a lot, and you're basically building a case against yourself. You're just looking for leniency here, really. It can result in your officers, not just the home health agency or hospice, but the officers involved. They can also be charged by the DOJ under the responsible corporate officer doctrine. Any admissions aren't privileged, so plaintiff firms may seek to get admissions under FOIA if you're kind of organization that's subject to that. Or, submitting parties should identify upfront any portion that it believes are protected from disclosure. And many states have their own self-disclosure protocol, and there's obviously other departments, the federal and state governments that have their various self-disclosure and whistleblower programs. So there's a lot of tattling either on yourself or on others. They're trying to get everyone to do the job for them, I guess, but you do get some benefits out of this, so it's something to consider when you do find some non-compliance. Go to the next slide. I think we're getting close to Richard's part. Yes, there we go. I'll hand it off. Richard can take CMS program.
Thank you so much, Les. I got to tell you that Les is one of the smartest lawyers I've ever been around. He is very astute at cutting right to the core of the problem, and he's got a way of speaking in just everyday English. So it's really, he's giving you a lot of practical advice during the course of this that's just kind of, it sounds like it's off the cuff, but oh my gosh, it's very valuable. So take it to heart. The most important thing he said, of course, applies in this situation also, which is get a lawyer involved. Get a lawyer involved early. If you think you're in a situation like this, don't guess. Don't try to do it yourself. There are lots and lots of landmines in these processes. There are traps that you could get into because you say too much or you imply too much that is not even necessarily something that happened. It just sounds like it, and then you go off on these rabbit trails that could open all of these problems. We're going to talk about the CMS self-referral disclosure protocol, which is the civilian aspect, civil law, mandated by Section 6409 of the Affordable Care Act. It applies only to actual or potential violations of Stark. As Les told you before, the OIG protocol has to have the anti-kickback statute linked into it somewhere. So you're talking about the criminal provisions. And it's going to clean up any Stark law violations that you have if they're accompanied in that situation. If it's Stark only, if it's a self-referral situation, this is what you're going to use. It's not an advisory opinion process. Again, it's just like Les's situation there he talked about. You're admitting guilt, essentially, and so you have to be careful about what you do. All other disclosures must be made under OIG's self-disclosure process. As we mentioned, you don't make disclosure under both protocols. It's going to be one or the other. The disclosing individual is called the disclosing party. This is available to all healthcare providers of services and supplies, including individuals and entities. Next slide, please. So just a recap of Stark law. It prohibits a physician from making referrals for designated health services, and we'll talk about those in a second, payable by Medicare to an entity for which he or she or an immediate family member has a financial relationship. That's going to be ownership, investment, compensation, if they're getting paid one way or the other, unless an exception applies. And there are over 30 exceptions. They're general and specific. I had a statistics professor in college one time handed out a joke test and said one of the questions was define the universe, be general and specific, give examples. That's kind of what you're going to be doing here. Prohibits anyone from submitting a claim for a service that resulted in a prohibited referral. It is civil, as we mentioned. It's not criminal. It's black and white. You don't have to have intent here. The act itself is sufficient. So if it happened, you're eligible to use this. You just want to get with your lawyer to find out, is this the right tool? Next slide, please. So what are designated health services that fall under the SRDP for Stark? Well, they could be home health services, occupational therapy services, radiology, clinical lab, inpatient, outpatient hospital services, parenteral, enteral nutrition, equipment, supplies, outpatient speech language pathology, DME, physical therapy, or outpatient prescription drugs. Next slide, please. Sorry. You can disclose this even if you're already the subject of a government investigation, audit, or other routine oversight activity, but the disclosure must be made in good faith. All disclosures must be submitted online via email. This is something that's happened in the last few years, and it used to be that you'd have the paper changing hands and such, but not anymore. This is pretty much the exclusive way you can make this happen. Disclosing party, your CEO, CFO, or other authorized individual must sign the certification that the information is truthful and based on good faith effort to inquire and investigate. A hard copy of the certification must also be mailed. So once again, this is an admission, so you want to be very specific about what it is that you are and are not disclosing here. Upon receipt, CMS automatically sends response email acknowledging submission. This suspends the 60-day repayment deadline, payments, etc., and that's important, until CMS issues a formal letter either accepting or rejecting disclosure. And that's why it's also important to have a lawyer involved, because if your offer gets rejected, then guess what? The 60-day deadline is back on, and you're going to have to come up with a plan B. So that should be something that's already in the works, and your attorney will help you get that done. Next slide, please. So that's the process. What are some of the considerations? Well, you can disclose, and even if it's already subject to government investigation, as we said, it has to be made in good faith, et cetera, et cetera. If the disclosing party is under a CIA, a copy of the disclosure needs to be sent to the OIG monitor to let them know what's going on. And again, you're talking about an admission to a violation here. So CMS may decide that the disclosure warrants referral to OIG or DOJ for further prosecution. So your attorney is not looking to help you avoid liability you're absolutely responsible for. You're going to talk about that. But what you want to do, what your attorney is there for, is to help limit the scope to what the violation actually was. What you don't want is this thing going broader, wider, bigger on a hunting expedition or a fishing expedition by the government. Because the government, when you're a hammer, everything looks like a nail. So you want to try to confine the arena of investigation to where the problem actually is. Next slide, please. You want, on the disclosure itself, you're going to be including your name, address, tax ID, MPI, CMS certification number of the disclosing part. If the disclosing party is owned, controlled, or part of a system, network, or other organization like a hospital system, description or organizational chart explaining the relationship, names, addresses, et cetera, how they relate and are tied in with the organization, its departments, et cetera. That all needs to be mapped out. What you're doing here, remember, is trying to not create questions. You're trying to explain as much as necessary. You don't want them to have to ask twice. So if you know the organization map needs to be disclosed here, you want to have enough detail in it to get to all the people involved, the departments involved, so they don't have to go hunting. Next slide, please. Describing the matter being disclosed, that's going to include the type of financial relationship that was involved between the parties, who those parties were, specific time periods they may have been out of compliance, the dates when they were not compliant, the relationship or behavior, and whether it was cured, the type of designated health services involved, again, the names of the individuals and or entities, and a description of their roles in the matter, who did what when. Next slide. You're going to be talking about why it believes violation of Stark law may have occurred. Here's the important part: the complete legal analysis of how Stark law applies to the conduct and any exception that may apply. You must include a point-by-point statement of which elements or of the exception were met and which, if any, were not. Discussion of the potential cause of the incident or practices. Was it an intentional act? Was it lack of internal controls? Was it a mistake? So here is a bit of an opportunity to help you explain yourself that goes beyond facts, and your attorney can help you with that. Next slide, please. So you want to disclose how the disclosure issue was discovered and when that happened, measures taken to address it and cure it so you don't incur future violations, and of course, when that occurred, efforts to restructure the problematic relationship or arrangements. How'd you fix it? Statement of the history of similar conduct or prior criminal, civil, or regulatory enforcement actions. You're just basically telling them everything that's happened to you before. That includes payment suspensions. Description of the existence and adequacy of pre-existing compliance program. And here again, this is why everybody needs to have a compliance program. It's not just the law. It's going to come into play in situations like this. And efforts to prevent a recurrence. So what have you put in place? Is new training, new internal controls, increased supervision? I mean, some of it, all of it. Have you added other things? These are all things you want to disclose. Next slide, please. Description of other appropriate notices to other government agencies. So remember, we talked about if you need to disclose to the OIG monitor on CID. This is going to include beyond that. We're talking about the IRS, Securities and Exchange Commission, state agencies, if they need to be notified. Any knowledge whether the disclosed matter is under inquiry by a government agency or contractor. Identify that contractor and individual representatives. You may have an audit going on. It's just full disclosure at this point. So any other investigations, any other inquiries, any other matters. Next slide, please. So for the financial analysis, which is the second part of this, you're going to complete a financial analysis related to the reported matter. That's going to include the total amount itemized by year, and that is actually or potentially owed. You got to indicate if these are estimates, and if so, how are they calculated? Describe the method you use for the calculations, the total amount per physician or physicians received as a result of violation. So you're going to break it down both by year and separately by the physician that received it, and a summary of any auditing activity undertaken, and description of the documents the disclosing party relied upon in conducting that audit. Next slide, please. So finally, for the certification here, it's going to be signed by the individual or CEO, CFO, or other authorized individual, officer of the corporation, if it is a corporation. Information has to be truthful, has to be based on a good faith effort to bring the matter to CMS's attention in order to resolve the potential liabilities relating to the Stark Law. Next slide, please. And then verification by CMS is the next step. So there's no specific time frame or deadline that they have to respond by. CMS requests access to all supporting documents and financial information without attorneys asserting privilege. And CMS will work with the disclosing parties counsel to obtain information without waiving appropriately claimed privilege. CMS may request additional information. Disclosing parties given 30 days to produce that information. Next slide, please. And as far as an outcome, CMS will not accept payments of estimated or presumed overpayments until CMS verification is complete. The disclosing parties should not repay amounts relating to the matter to contractors and federal programs without CMS consent. And if they consent to any prior payments, disclosing party must agree in writing that it's not an agreement as to the total amount or loss the programs have suffered, and doesn't relieve the disclosing party of civil, criminal, or administrative liabilities, doesn't offer defense. It's basically, you can't send the check and say paid in full and you're done. Now, you can make a partial payment. They can accept it. They can acknowledge it. You have to make sure of that. If you're going to have your attorney involved, make sure that happens. But generally, you're going to wait until you've got CMS's approval to start making payments. You're going to come up with a repayment plan to do that. It doesn't mean that's all you're going to wind up having to pay, but you're going to try to negotiate as much as you can on this particular point. It could be referred, though. That's what happens. Next slide, please. CMS can decide to reduce the amount owed for a Stark Law violation, but it's not obligated to. They will consider the nature, extent of the improper legal practice, the timeliness, the disclosing party's cooperation in providing additional information, litigation risk, financial position of the disclosing party, and any other factors that are deemed appropriate. I've got a bit of a war story on this. I had to utilize a similar settlement in this situation. And part of the situation that involved this was that he was one of only 3 providers of that particular service in a very large multi-county area. So it was part of the problem, and the fact that it was an innocent mistake. He's another one of those doctors that was a great doctor, but not so great a businessman, just didn't keep track of stuff, didn't know. So it was more like an innocent mistake, but from naivety. So that can be involved. They did take it into account, and the amount that he could have been hit for, they were initially asked for $2.5 million. We wound up settling for an amount less than $1 million. So significantly less, and that made a huge difference in his life. Next slide, please. Generally, once an overpayment is identified, the provider must report and return the funds within 60 days. However, under the SRDP, once a disclosure is submitted, this deadline is suspended until a settlement agreement is reached. Provider withdraws from the SRDP, or CMS removes the provider from the SRDP. You don't forget to issue refunds to individuals, beneficiaries, or any other for co-payments and deductibles. That's something you have to follow through on, or you're going to have another violation. Because remember, it's money you weren't entitled to. Next slide. And here's an example of the chart, the settlements that have incurred between 2011 and 2023. You can see from the charts, it started out a little over 700,000. Now they're up to over 12.5 million. They started with 3 settlements. Now they're up to 677. So it has jumped a lot. And you can see a dip or two there in the COVID years between 2019 and 2021. And that explains the downage. But you still had 36 in 2020 and 27 in 2021. Then it jumps back up to 103 in 2022. So it's more popular. It's being used. The government does want to use this, and they will be open to listening to you. And that's the good thing about it. One note, as of the end of last year, an additional 267 disclosures to the SRDP were withdrawn. They were closed without settlement or settled by law enforcement partners. So the totals are aggregate. Next slide, please. So the caveats here, remember you're making the disclosures essentially an admission of a violation. Therefore, what you say and how you say it are critical for its success or failure. This is why you have counsel involved. Think through your decision to disclose very carefully. There are no appeal rights, very short deadlines. You may not resolve False Claims Act or civil monetary penalty issues. There may be more money that has to be paid, or DOJ issues. Consider all the possible consequences and your waivers of defenses that are being involved here. So as I said, involve counsel, maximize your chances. If you get to a point where you think you need to use or may need to use either of these protocols, you just remember it's out there and say, well, I'll just tell them and pay them. Oh, for heaven's sake, the first thing you should do is call counsel. That's it. Don't even try doing this yourself. Too many landmines, too many problems. Next slide. I think we're at the end or close to it. There's Les's contact information. There's mine. If you have any questions, we'll be glad to try to answer them now. And if you don't, you can always email us. We appreciate being able to come and talk to you today. Do we have any questions, Gio?
No, it doesn't seem like we have any questions.
Well, we sure appreciate the chance to talk with you. Les, I want to thank you for taking the time out of your day to come and speak. Always a pleasure.
Yeah, pleasure here.
All righty. We will see you next time around, folks. Thank you.
Thank you so much to our presenters, Lester and Richard, for that amazing presentation. And thank you to all of our attendees for joining us today. I will be sending a copy of the PowerPoint slides tomorrow. And if you have any further questions, definitely reach out to them. Have a great Tuesday, and we'll hear from us soon.